If you're in the process of getting a divorce or you've already gotten a divorce, should you update your estate plan? Hi, I'm attorney Paul Delary, and I do estate planning and business planning for my clients. And we'll go through some of the things that you should consider that, frankly, your family law attorney may not have thought about because they're focused on getting you through the process of a successful divorce where you come out the other side, hopefully in one piece. But I'm saying that if you've gone through that process or you're going through that process, it also has a lot of implications for your family and for yourself that we're going to talk about in this video. So, first of all, let's talk about the healthcare power of attorney. Now, that's a document in which you name someone to make healthcare decisions for you, medical decisions, if you're not able to. For example, you're in a car accident and you're not able to communicate. If you're going through the divorce process, then uh, then you're and you have no documents, then your spouse uh, can go to the hospital and talk to the staff and make decisions. If you do have a document naming your spouse to be in charge, they have that document. They'll take that to the hospital, show it to the nurses, to the staff, and they'll be able to make decisions, medical healthcare decisions for you. And again, potentially end of life kind of decisions. Um, if you've already gone through the divorce is finalized, then by operation of law, there's a statute, what is it here? ARS 142804, that basically nullifies or invalidates uh, revocable documents like that, including a healthcare power of attorney. So if you've gone through the divorce, you had named your spouse uh, as as the agent, as the person to be making healthcare decisions for you, then that's legally no longer valid. However, you get the let's imagine this: you get the divorce, you get in a car accident, uh, your now ex-spouse, ex-wife, ex-husband finds out, rushes to the hospital, waves the document. Hey, I'm named here to be in charge to make decisions, and they're gonna follow that. Uh, the hospital staff, the nurses and whatnot, they're not going to be going through the court records and investigating whether or not there's a divorce decree. I mean, that happens never. So it could create a situation. Let's say you have kids who are also there. You have a spouse waiving a power of attorney. I mean, frankly, if you need a surgery really fast, like a life-saving surgery, and there's a fight between your kids or your family and your ex-spouse who's waiving this healthcare power of attorney, the staff is probably not going to do anything. Okay, they're going to stop, and they'll let the family kind of work it out. So you're sitting there or laying there in your bed, unable to communicate, needing a life-saving treatment, and the medical staff will not act because they don't want to be sued. You know, I mean, hospitals get sued all the time for making bad decisions, and they would rather make no decision than a bad decision. So if there's a conflict between your ex-spouse waiving this power of attorney and your family saying no, 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 they got a divorce, um, it best case scenario is going to delay things. It's going to delay this life-saving surgery or life-saving treatment that you need. So how do you fix that? Just get a new power of attorney. It's so simple. If you're in the divorce process or if it's after divorce, just get a new healthcare power of attorney. Now, the second document that we talk about is a general durable power of attorney. Now, what in the world is that? Well, okay, a bunch of different words. General, I'm not sure why they use the word general. Um, General really means financial and legal. So it's a power of attorney that authorizes someone to make, to pay bills, to transfer title to your house, to sign contracts, that kind of thing, financial and legal kinds of things. So that's what a general power of attorney is. Now, the word durable means has nothing to do with the quality of paper that it's written on. It means that it survives, or it's still in effect, uh, even if you're unconscious or even if you're incapacitated. Okay, so same scenario. Uh, you get in a car accident, you're laid up in the hospital, you're going through a divorce, okay, not finalized yet, and um, let's say you have a power of attorney naming your spouse. Okay, well, that's still effective. Okay, your spouse now. Okay, there's also this thing, this temporary restraining order on transferring assets and whatnot. Um, that's in effect. However, that mainly means that the spouse is not supposed to transfer things. It doesn't like automatically shoot out to all the banks and notify them. No one's supposed to do anything. Um, so it's a don't do this kind of an order uh, to you and to your spouse. So um, there's actually nothing then preventing, uh, I mean, technically, legally is preventing, but from a practical standpoint, there's nothing preventing your spouse from using that power of attorney to get access to your bank accounts and maybe that's good. Maybe you want that. Maybe you still trust your spouse. You just don't want to be married anymore. I mean, perfectly common. Or, um, but what I'm saying is that your spouse, if this document is still live, if the divorce decree is not granted, that general power of attorney is still live, it's still effective. And so, just think through, do you want the person you're getting a divorce from to have power over all of your assets and your legal matters? Maybe, maybe not. Also, uh, if you're getting a divorce and you don't have this document, then maybe it's a good time to be doing that. Um, Married couples, I think, okay, banks don't do this, but um, in some scenarios, there's a little bit of a like allowance given to a spouse to make decisions on behalf of the other spouse. Um, Again, signing the contract for the hospital. Okay, that's not a healthcare decision. That's a contractual financial decision. So, if you want your spouse that you're getting a divorce from making that decision, fine. If not, you really need to get a new general durable power of attorney. Now, after the divorce, same thing. Uh, by virtue of the Arizona law, by virtue of that statute that I mentioned, and I don't remember it, it's ARS 142804. By virtue of that, this general durable power of attorney is now canceled, okay? Or at least with respect to your spouse. So now that can create, let's just imagine a perfect scenario. You have this general durable power of attorney, you get the divorce, um, and now just by operation of law, ex your ex can no longer make decisions like the provision in the document appointing your ex to make financial decisions is no longer effective. Okay. um, However, you've created a situation here that, let's say the next in line is your oldest child who's 18. Okay. um, Oldest child needs to go to the bank to get access to your bank account. Well, the bank is going to, I'm telling you this, they will ask for a copy of the power of attorney. They'll send it to their legal department, and they'll say, well, here it names your ex-spouse as the um, well, no, you're not the one doing this. You're laid up in the hospital. So your 18-year-old child is taking this document to the bank. Bank sends it to their legal department. Legal department says, well, the first person named is uh, Betty Lou or whoever it was. Okay, the ex-wife, the ex-spouse. And then you'd say, well, they got a divorce. Oh, well, you have to prove that. Okay. I guess I have to drive to the superior court and get a copy of the divorce decree. So you drive to the court, you get a copy of the decree, you go back to the bank, they have to upload it, send it to the legal department. They make sure it's valid. Oh, well, that wasn't a certified copy. You just gave us a regular copy. You need to go back to the court and get us a certified copy. Okay, you drive back to the court. Okay, do you kind of get the point here? So way easier just to get a new general durable power of attorney. Way easier. Next, let's talk about your will and trust. Okay, so let's talk about a very common situation in which married couples don't have an estate plan and they simply have everything named jointly. Okay, so you filed for the divorce, but the divorce isn't granted yet. Everything is joint. Well, that's what's going to happen. If you named your spouse as the beneficiary to your bank accounts and beneficiary on your house, maybe your house is still held in joint tenancy with right of survivorship. That's exactly what's going to happen. Okay, the house is going to go to the spouse that you're getting a divorce from, and the bank account's going to go to the spouse that you're getting a divorce from. The divorce decree has not been granted, so um, so those so your spouse's rights have not been severed, and so that's what's going to happen. Now, if you do have a will and a trust, kind of the same thing. The divorce decree has not been granted, and whatever it says in the will and the trust, that's what's gonna happen. Okay, so the very common situation for married couples, the will says everything goes to the spouse. That's exactly what's going to happen. Now, maybe you had an understanding, maybe you had a blended family, and you had an understanding that the spouse is going to take care of your kids, or maybe uh, somehow take care of your kids. That ain't going to happen. Okay, everything's going to the spouse. So that's before the divorce. So good reason to get a will minimum. Get your will done. Um, Always better to have a trust also. And what I'm talking about with the trust, I'm talking about a living trust, revocable trust, same thing. Okay, different words, same thing. Um, After you get a divorce, now what should you do? Well, uh, just by operation of law, that 142804 statute says that any revocable rights that were given to your former spouse, your ex, um, those are now nullified. If you named your ex, now ex spouse, to be personal representative of your will, that's done. That's canceled. If you wanted everything going to your ex-spouse, that's canceled. If your ex-spouse was going to be trustee, successor trustee of a joint trust, that's done. That ain't going to happen. Um, so now you need to think what you actually do want to happen. So now you might think, well, I got a divorce. It severed my wife, my ex-wife, ex-husband. Everything's fine, right? Okay, hold on. Do you have minor children, or do you have any dependents? Um, well, if you have minor, if you have children who are also the children of your spouse, then your spouse is most likely going to become the guardian of your minor children. And if you have, if you didn't have a will, and everything's supposed to go to your minor children, well, minor children can't own property. So now there needs to be a conservatorship to hold the property until your children turn 18, at which point, I don't know who thought of this, but that's just the way the law works. Okay, it's not a great solution, but when your children turn 18, then they get everything. Uh, Again, not a super great situation because 18-year-olds don't know how to handle money. Okay, whatever they spend it on is going to be red, fast, and shiny. Okay, sports car, in other words. So Um, that's a really good reason for you to have a new trust where everything for your minor children can go into the trust. Okay, number one, if you have minor children and you have money and you die, have your money and property go into the trust for the benefit of your minor children. And then you can actually specify, okay, I don't want them getting everything at 18. I want them maybe getting part at 25 and part at 30, or it's discretionary. You can talk to your estate planning attorney about that part. Also, if you have minor children, think about who you want to become the guardian of your children. Now, it's going to be the default, the fallback or the assumption is that the other parent of the children is going to become the guardian. But, let's say you don't want that. Maybe the person is a jerk or an alcoholic or a drug abuser or, physically or mentally abusive or something like that. Um, you need to appoint or nominate a different person to become the guardian. So a couple things here. Um, you can't just wish it, and you can't just tell your best friend about your wishes. That's not legally effective. You need to put it into a document, a legally effective document that in which you name the person you want to become the guardian of your minor children or any other dependents you might have. Usually done in a will, a last will and testament. Okay. Now, let's talk about the situation I just gave you. Okay. The other parent just is not fit, alcoholic, abusive, that kind of thing. Um, they're going to be the natural person to be appointed unless someone goes to court and fights and proves that a different person should become the guardian of the children, someone that you name, someone that you've picked. So how do you do that? Well, you have, not you, you're dead, but whoever, like the guardian that you name is going to have to hire a lawyer and go to court and fight for custody, for guardianship of your children. How's that going to happen? Well, there needs to be some money. If you have enough money for this, um, designate it in your trust that this money is, this pot of money, 50,000, 100,000, whatever it is designated for the purpose, if necessary, for the purpose of my guardian to take care of my kids, for legal fees, necessary, that kind of thing. If you if you're short on money, get some term life insurance. This is a perfect situation for getting some term life insurance. Even just, I mean, well, okay, if you're short on money, you might be thinking, well, okay, I don't even need, why am I watching this video about planning who gets all my stuff? Because my stuff maybe isn't worth that much. But um, again, get some term life insurance. And that can be enough to fund your funeral, fund your children's future education, and fund future litigation against this abusive alcoholic um, parent that you don't want to become the guardian of your children. So that's another consideration. Okay, another reason you absolutely need to get your estate plan put in place. So now let's talk about beneficiary designations. And I'm talking about who you name to be beneficiary on such things as your IRA, individual retirement account, your health savings accounts, annuities, bank accounts, anything that has a beneficiary designation on it. There's a Supreme Court not too long ago that said that even though there's a state statute that says um, your now ex spouse is no longer has any rights to your property. Um, the beneficiary designation trumps that. Let me say that a different way. If you have a beneficiary designation on, whatever it is, whatever account, your IRA, your employee retirement plan, whatever has a beneficiary designation on, that's what's going to happen. Do not rely on the fact that you got a divorce for fixing that. You need to specify a new beneficiary. And okay, that's simple enough. I just told you to do it. You can take care of it. But if you have minor children, think this through. Again, a minor child can't really be the beneficiary of a of an account. They can't hold it. So what usually we attorneys suggest is to put it into a special kind of a trust for the benefit of your children, so this whole thing doesn't wind up in court. Okay, so that's another thing you should think about. Just make sure you update your beneficiary designations. Talk to a lawyer if you have any questions. Another thing, if your divorce is now finalized, you need to give a copy of your divorce decree to your estate planning attorney, so that your estate planning attorney knows what kind of obligations you have. Are there obligations for life insurance? Are there obligations to maintain, money for the benefit of your kids or something like that? Just maybe it affects your estate plan, maybe it doesn't, but just it's always a good idea to make sure that whoever's working on financial things for you knows about your obligations under your divorce decree. And oh, speaking of obligations, life insurance. This is another thing. Make sure that you or your family law lawyer is following up regarding life insurance. If the other spouse is supposed to be maintaining life insurance for you or for the benefit of your kids, it's extremely common that that gets canceled at some point in the future. Okay. And then your ex spouse dies, there's no life insurance, then you have to go to court and fight for that. So it's much easier to prevent it just once a year. Uh, you ask for verification that the life insurance is still in effect, or you have your family law lawyer do the same thing. So that's another thing. Lastly, let me say that we want to be your estate planning attorneys. I want to be your estate planning attorney. Um, I've been doing this since 2001, estate planning and business planning and this kind of thing specifically since 2001. I'm AV rated preeminent through Martindale-Hubbell. That means Martindale-Hubbell is the oldest attorney rating system in the country. So all you have to do is go to removemyx.co, removemyx.co, not com. We couldn't get that one. So .co, and that will take you to the Start Here page on my website. There, you just fill in your name, contact information, and you can tell us briefly about what you're wanting to do. And also, if you want to get $250 off the legal fees, just mention the attorney or mention who referred you to this video or to the checklist that the estate planning checklist for people getting a divorce. So mention who referred you. You get $250 off, and that's it. Okay, I really look forward to working with you.